going to take up Senate Bill 2451, Mississippi Principal Income Act. And I'm gonna, I have, Miss former Rep Jim Simpson here. If y'all want to come up here. Yep. Yeah, sure. No, that's fine. Please come forward. Um, just right over here. Senator Thompson, you want to give the brief overview of the bill?
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, Senate Bill 2451 was brought to my attention by Mr. Simpson and Mr. Hoff Esquire regarding something to do with trusts and estate work. And I don't practice in that area of the law.
Yeah,
So-
and let me just say, I've talked to them, so we've brought in the expert. So rather than letting Senator Thompson and I mess it all up, we're going to turn it over to you. I will say this for the benefit of the committee. It's a statute that needs addressing as this is my term. It's not capturing what's out there. And so, Mr. Hoff, if you'll just give a brief kind of reason why we have the bill here and what we're trying to do with it.
Senate Bill 2451 amends Section 9117-401D2 of the Uniform Principal and Income Act. The amendment doesn't affect state revenue. It only affects the allocation of a receipt by a trust between principal and income when there is an excessively large distribution to a trust by a corporation. The statute itself was written by the Uniform Laws Commission. There are some words that are used in it and some phrases that are used in D2 of the statute that are hard to interpret by both lawyers and courts and bank trust departments. My effort is to clarify those provisions so it's easier to administer and make a determination whether a receipt should be allocated to the income beneficiary or the principal beneficiary.
And why do we need this bill versus what is currently in statute?
What's currently in the statute, it uses some words that are confusing. It also has calculations that are hard to determine. This just clarifies it all and adds a few additional words and phrases to the statute to make it clear for both lawyers, beneficiaries, bank trust departments, and the courts to interpret it. The only other place where this statute has been litigated has been California. And surprisingly, California made a very common sense decision to amend their version of the statute to basically what I have proposed to the
California and common sense usually don't go together, but.
No, they don't, but in this case, they actually do.
Okay.
And we're just trying to conform the statute to what makes good common sense, what's easy to calculate, so that a bank trust department or a beneficiary doesn't have to expend an excessive amount of money and has more predictable results when a trust receives a large distribution. For example, in my case, the company that this was generated from distributes its retained earnings sometimes 2 or 3 times its income. And that's, in my view, not fair to the principal beneficiary who, because they're in effect distributing out part of the body of the corporation to the income beneficiary. This makes it a clearer determination for a trust department to say what is principal and what is income.
Okay, open it up to the committee. Any questions? Senator Barrett?
Mr. Chairman, is what you've proposed, you've referenced California, is this the industry standard?
Um, there is really no industry. It's just two states that have litigated this, Mississippi and California. But yes, this was the solution that California ended up with, and this is the solution I'm proposing.
Thank you.
There really very few people in the state of Mississippi that even understand it or work with it.
Senator Thompson?
Thank you, Mr. Chairman. Mr. Hoff, so this is money that the trust, that is coming into the trust, and the trustee has to determine how that's going to be
That's correct.
accounted for.
The trustee holds the stock but either a listed company or a closely held company. In my case, it's a closely held company, but a number of years ago, Microsoft made a large distribution and trustees were faced with the same problem back then.
And the trustee, he or she stands in a fiduciary relationship to the beneficiaries of the trust, correct?
Right. The trustee has a duty of impartiality to both the income beneficiary and the remainderman. Under Article 8 of the Uniform Trust Code, these to treat both of them fairly, and this just makes it easier for a trustee.
And that was my question. So this clarifies for the trustee when those incomes are received, how it's to be allocated for tax purposes,
Yes, sir.
so that later on down the line, the beneficiary can't come back and say, you miscoded or misallocated.
Right.
That income is,
Right. It makes it all much more predictable.
okay. Thank you, Mr. Hall. Thank you, Mr. Chairman.
Thank you. Any other questions? Do I have a motion? Motion is title sufficient, do pass. All in favor say aye. All opposed? The motion carries. That will go to the full Senate. Thank you very much.
Thank you for hearing me.
You have to acknowledge the superiority of the Senate, Representative Simpson. Okay, thank you. Yes, thank you. All right, I'm gonna call up Senate Bill 2482, Mississippi Electronic Court System, Senator Barrett.
Yes, sir. Thank you, Mr. Chairman. I hesitate to use this as a simple bill, but essentially what this bill as authored would allow Mississippi public defenders to have free access to Mississippi electronic courts. If I could, Mr. President, Mr. Chairman, I would like to add or offer an amendment to include prosecutors. I understand that district attorneys' offices, they have free access to it, but in speaking with a gentleman at Supreme Court who handles MEC, county prosecutors and maybe city prosecutors do not have access to it. So as it would relate to an MEC related case, this would allow public defenders and if the amendment is accepted, prosecutors access to MEC at no cost to them for doing their job.
If you want to make that amendment at this time, that's fine. And
But yeah,
do you have where you would? Council's saying we can, if that's your amendment, he can work with that.
okay.
Is that your amendment?
It is, Mr. Chairman.
Okay. Before we vote on the amendment, I think Senator McCon has a question.
So just a quick question. The justice courts in our state are not on MEC, nor are municipal courts. So
Correct.
tell me your reasoning behind the prosecutors in these facilities being given MEC access.
Well, county prosecutors are. Their cases are on MEC, and that was his specific reference.
You're telling me justice courts are on MEC as a whole right now?
No, I'm talking about county courts. I don't mean justice courts. I mean county courts wherein the prosecutor may be dealing with preliminary hearings, things of that nature. I mean in counties specifically with a separate county court.
Okay, so I guess my question would be then, I don't know if the amendment would satisfy that. If you're talking about just the county courts, the counties that have a county court, you're providing access to the county prosecutor there.
Yeah.
I don't really, it doesn't really matter to me one way or the other. It's just, I don't know that we're doing justice if we're going this route.
Yeah, well, as you know, county or municipal prosecutors or prosecutors that handle justice court or prosecutors that handle county court, if they charge someone with possession of a firearm by a convicted felon, they have to search MEC to find that felony, and they're doing so at a cost to them to do their job. So that's why I referenced municipal and justice court prosecutors. I'm just trying to make it palatable for everyone. And I, especially, this would not apply to cases in which a defense attorney was privately retained. This would only apply to cases in which you were specifically appointed to represent an indigent defendant. Likewise with a municipal prosecutor or county prosecutor, if they were referencing a particular case, trying to find if this person had a prior, felony shoplifting, or some case that is an aggregate case. That's why I referenced the prosecutors.
You know, and I guess my rebuttal to that would be then maybe our investigators at the sheriff's offices would be more apt to need the access to the convictions versus the county prosecutor, him or herself, as they're the ones preparing the charges at the end of the day and just bringing them to the county prosecutor, who then brings it forth to the preliminary hearing or whatever it may be. I find that my county prosecutor does not actively stay in a day-to-day, because that's a full-time job if you ask for that.
Yeah.
I don't have an objection to your amendment. I mean, I don't think it's needed at this point, but I don't have an objection to your amendment.
Well, certainly, as you know, the circuit court district attorneys and assistant district attorneys, they have free access. The premise behind the bill was we have public defenders that are shelling out of their pockets $200, $100 a month, or excuse me, a quarter for their MEC bill. It's not covered by the counties. So the premise behind this was if you're going to represent somebody, you should, on an appointed basis, you should be on a level playing field. So that was the initial bill. And again, I took an email from an individual at MEC who said he thought it would be more palatable if county prosecutors were included.
But your amendment is county and municipal.
Yeah, and I think it's the same principle in that in every municipal court I've been to on a preliminary hearing basis on a possession of a firearm by convicted felon, they have to reference and first prove that that person is a felony. So they have to pull that felony off of MEC or somewhere. And that was the premise behind that.
I understand. And I mean, I think we're looking at different paths here, but that's not objectionable to me, as I said.
So so at this time, we will go to the amendment. Can you restate the amendment that you are asking?
Yes, sir. I guess specifically it would be tied to cases that specifically deal with a matter relating to a Mississippi electronic court case in which a prosecutor, it's my understanding most already do have access, but specifically public defenders have access to Mississippi electronic courts for free. And I think MEC guy said county prosecutors
So
would be
you heard,
specifically.
so we'll vote on the amendment. So we're on the amendment. You've heard the amendment. All in favor, say aye. All opposed? The amendment carries. Okay, we're back on the bill as amended. Senator Turner Ford.
Thank you, Mr. Chairman. And I don't want to quibble because I've seen the MEC invoices and, sometimes they can be relatively minor. But, my question would be, perhaps would it be more appropriate as it relates to the county prosecutors to submit an invoice for reimbursement for those costs that they've expended to access MEC for those certain levels of cases? And I'm not sure if I'm directing my question to the,
I would have no
Or the
objection
chair.
with that. I mean, the premise behind the bill is that public defenders should be on an equal playing field.
Well, let me say this. We have an amended bill in front of us.
Yes, sir.
That was a question. He said he has no problem, but that's the answer to the question.
thank you, Mr. Chairman. So when recognized, I would like to offer an amendment.
Okay, you're recognized to offer that amendment.
And that would be my amendment that, county prosecutors and, any other prosecutors that are involved would submit an invoice for cost reimbursement. Yes. Well,
You-
I think yes, I would say for both.
So your amendment is for cost reimbursement to the public defenders and to prosecute the county prosecutors.
And my reason for saying that is because I think both types of attorneys can handle other cases outside of their commitments for county prosecutor responsibilities as well as prosecutors, public defenders and prosecutors.
Okay, so you've heard the amendment. Any questions on the current amendment, Senator England?
Thank you, Mr. Chair. And I may have just not heard this part. Who do the invoices go to? So who is this payment going to be made to?
I make my payments to MEC, so I would assume maybe they could go to the Administrative Office of Courts to be handled.
Okay, any other questions? Okay, we're on Senator Turner Ford's amendment. All in favor, say aye. All opposed? Okay, that amendment carries. Now we're back on the bill as amended twice. So, any other questions? All right, do I have a motion
Title sufficient, do pass
as amended?
as amended.
Committee subs, thank you. So, the motion is title sufficient do pass committee substitute. All in favor, say aye. All opposed? That carries. Thank you very much. Next, we'll go to Senate Bill 2792, nonprofit corporations. You good with that?
Yes, sir, Mr. Chairman. That's actually very simple. If you remember last year, we passed this bill requiring a reporting for those who receive public funds. Question came from the Secretary of State's office, and I believe there's a House version of this as well. They just asked for us to change one little line back there. Previously, in line 48, it said our revocation of nonprofit status, and really Secretary of State's office has no ability on nonprofit status. So the request was to pull that out and just go with subject to penalties of administrative dissolution. And that's all they've asked to do that. There was some questions as to whether churches are involved and all that. There is a definition in here where it says religious corporation. If you are not a religious corporation, you have no reason to file. But if you are a nonprofit corporation pursuant to the statute, you would be required to file that report. So the Secretary of State's office done a great job of getting that set up, and that's the bill.
All right, thank you. And while I'm on that, I want to say thank you to the subcommittee chairs for working on the bills and all that. So thank you. Any questions? Motion is title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? The bill carries. All right, we're going to go to Senate Bill 2886, Mississippi Domestic Violence Fatality Review Team Law. Do we have anybody here from the Domestic Violence Coalition? Okay, come on. I'll present that bill. To make, um, make a long story short, have worked with, yeah, come up here. I'll explain it. And then if people have a question. So what the bill before you is comes to us from a coalition of domestic violence or domestic violence coalitions across the state. And, they have, this bill is modeled after ones that have been passed in other states. The short of it is that what it is doing is requesting to create a review board of homicide cases to look at, to determine and get to and study the causes of domestic violence. And it is not in any way interfering with law enforcement. It is simply to allow the review to occur. If you actually were in Judd B yesterday, we had some discussion on that. One of the examples is like when there are cases of violence that involve strangulation, that is a very good, in fact, it's a very significant factor that you could end up in domestic violence homicide. And so this has been, the idea behind this is to get at the root cause, or to at least study and look at the what is leading to our domestic violence situation in the state. And so that's the bill. And so I'm going to ask you to please introduce yourself, and then if there's anything that you can add to what I just said. Thanks.
Absolutely. Thank you, Chairman. My name is Luis Montgomery, Public Policy and Compliance Specialist with the Mississippi Coalition Against Domestic Violence, a statewide domestic violence nonprofit here in the state of Mississippi. The chairman did a really good job of really explaining the bill and the basis of it. Really, the core and the premise of this bill is just to identify the patterns of domestic violence fatalities throughout the state, right? Identifying those underlying causes, any correlations and trends, to really identify what gaps in the system there are. We really wanted a board that was make up of different career backgrounds, or anybody who had a hand in providing a service or addressing a domestic violence issue in the state. And so with that, we basically formulate a report every 1 to 2 years to provide to these different committees, which would basically explain the trends that the board has identified, as well as any legislative proposals to better inform not only our state legislators on how to better respond or provide legislative proposals as far as it relates to domestic violence, but also to our shelter service providers throughout the state who need a better understanding of where they need to pour their resources into, and to kind of identify what are the risks and what areas of the state need to be addressed with a little more care than others.
Okay, thank you. Do I have any questions on the bill? All right. See any questions? I'd ask for a motion. Motion is title sufficient, do pass. All in favor, say aye. All opposed? Okay, that bill carries. Thank you very much for what y'all are doing. Okay. Next, I'm going to go to call up Senate Bill number 2472, pesticide seller and manufacturer. John here, and do we get Farm Bureau? I think many of you are familiar with this bill. 2472. This comes to us at the request of Farm Bureau amongst a number of other our agriculture friends. It's actually a very straightforward bill. If you look at the language in section 1, it simply states a manufacturer or seller of a pesticide registered with the EPA under the Federal Insecticide Act shall not be liable in a civil action related to the labeling when it's a failure to warn, specifically in a failure to warn. For the members of the committee, there is a federal cause of action remedy. I've even been told there's multi-district litigation that is going on in these situations. I know that this bill was discussed in the Agriculture Committee hearing that we had, that the Agriculture had. As you can see, there's quite a number of co-sponsors, and we appreciate where they're coming from. As you heard, it's been a hard, I guess, year, to say the least, for our farmers. Delta Council, Farm Bureau, amongst others, are behind this bill and see this as a benefit for our farmers. And that is what the bill does. So, do we have any questions? Senator Thompson.
Thank you, Mr. Chairman. I just became aware of this bill earlier this afternoon, and have a couple questions about what exactly we think this bill does or is trying to do. Where would this be codified if it were to be passed?
That may be a question for council.
I don't see where it references anywhere.
Because it would be new language in the code.
Title 11 of the other immunities.
Being Title 11, 163, thereabouts. That's the Mississippi Products Liability Act, correct? It is. The Mississippi Products Liability Act is designed to protect manufacturers and sellers, correct?
I'm sorry, say that again?
The Mississippi Products Liability Act, it's there to protect manufacturers and sellers, correct?
I'm no expert in that area, but I would say that it's there to protect everybody.
Okay, well, it doesn't create a cause of action against against farmers directly, does it?
You mean the Products Liability Act?
Correct.
I don't know.
That cause of action is against the manufacturer or the seller. In the short title, it references a limited immunity. Can you tell me what the limitation on the immunity would be for those manufacturers and sellers of these pesticide products?
Okay, well, if you look at line 16, and this, I think, and maybe I didn't do a good job of explaining it, but if you look, starting at line 14, that in accordance with the sections there and with the United States Environmental Protection Agency, under that federal law shall not be liable. So you can argue that the immunity is in the state. However, and I will submit this to you, that, oh yeah, thank you. Council's pointing out that in line 19, if the pesticide at issue bore a label approved by the EPA. So I wouldn't submit that it's complete immunity. What I would say is there has to be a label by the EPA under the federal act. To put it another way, if you don't have that, then you don't have, excuse me, immunity. But so that's why it's very narrowly tailored, and it's there for that, for this specific reason. And put another way, if it hasn't gone through the EPA, then it doesn't apply either. So you don't have immunity in that. So you have a pesticide, it doesn't check the boxes of EPA under the FIFRA, and at the time of sale, all those things don't allow for immunity.
So long as they go through the labeling process.
Correct. And
Required by the EPA.
correct. At the time of sale, and as it has been explained to me, that the EPA process, while we're not all in favor of the EPA at times, it is the standard by which the companies are regulated. And if they are regulated and they have complied with the EPA regulations, then yes, only from a state perspective is it very limited. And there are cases, obviously the remedy would be in federal court. And my understanding is right now there's multi-district litigation going on. And so it does put things, creates a consistency. And I've been told, this is something that the farmers, if we don't have the pesticides, they can't grow their crops.
And consequently, if the farmers get leukemia from a pesticide 30 years from now, they would have no cause of action against the manufacturer of that pesticide if this were to become law, correct?
Well, okay, I personally don't do that type of law. I would say that, again, it's very limited in this situation. So if they got like you said, leukemia, and there could be proof, and there was no label approved by the EPA under FIFRA at the time of sale, then yes, they could recover.
What happens in the case of the manufacturer who either negligently, accidentally, or intentionally makes a misrepresentation to the EPA and is able to secure a label under this federal code section here? Would that manufacturer have any liability under this law?
That I don't know.
Why does this bill include sellers? Under our current Mississippi Products Liability Act, innocent sellers are already immune. So why would we have to take the additional step to include sellers here?
Well, and look, what this is trying to prevent is and this is me using the term, the total eradication of pesticides that are valuable in the agriculture industry. And so I would submit that you have sellers in there so that you capture, I guess, everyone that's relevant.
Thank you, Mr. Chairman.
Thank you. Have any other questions? Any questions? Do I have a motion? Motion is title sufficient, do pass. All in favor, say aye. All opposed? The ayes have it. Called for a division. All in favor, raise their hand, please. All right. In favor, raise your hand. 5, 6. Okay. All against? The bill passes 8-6. Thank you very much. All right, next, we're going to go to Senate Bill 2766, adoption petitions, and that's Senator McConn's bill. No, thank you. 2766.
Mr. Chairman, it's pretty easy. This is one we passed out last year, kind of got caught up there at the end and some of the debacle that might have taken place between the House and the Senate. The House has assured me they are apologetic. But what this bill does in the definitions of the adoption statutes and just in the adoption statutes, it says that a medical doctor or a nurse practitioner have to sign off on a health certificate. In Mississippi, we recognize DOs, doctors of osteopathic medicine, as physicians in the state of Mississippi that do a great job taking care of our people. The question was, why are they not included in this? The judges that I've talked to, which are very good friends of mine, have said that, well, we have to interpret it as medical doctors and MD. Well, the Department of Health, not Department of Health, the MSMA has gotten involved with this and said that's inconsistent with statute in Mississippi. We need to get that cleared up. So we've got it where to include DOs as well. So from this point forward, about half of our doctors are DOs now. So we're glad to have that. That's the explanation of the bill. Mr. Chairman, I would entertain questions.
Thank you. Any questions?
Title sufficient, do pass.
Motion is title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? That carries. Thank you very much. All right, we're going to go to Senate Bill 2893. We have council on. Do we have just Jordan Carpenter? Okay. We'll pull that bill up. 2893, Senate Bill 2893. So what we had last year, and there was between both the House and the Senate, make a long story short, we had what was deemed parental rights bill. There has been a movement, I guess, and we've had various laws that we've passed to ensure the rights of our parents. Last year, the bills that came through, it led to a lot of different things. They were, in my opinion, overly aggressive. And so what you have before you is, and by the way, the House, who we love them over there, they stuck the bill in a couple different things. At the end of the day, what we have before us is a bill, a standalone bill that has addressed areas of the law in Mississippi that honestly is overreached by the government. And it also establishes that, as you can see on lines 32, that a parent of a minor has a fundamental right for the upbringing, education, care, and health care of a minor. And so with that, I'm going to let Jordan Carpenter introduce himself and then explain the intent behind the bill. Jordan, can you hear us?
Yes, sir, I can hear you. Can you hear me?
Are we on? To allow.
Can you hear me, Mr. Chairman?
Oh, there we go. Thank you. We can hear you now, Jordan.
All right. Yes, sir. Good afternoon, Mr. Chairman, distinguished
Good
committee
afternoon.
members.
And if I may, Jordan, if you can introduce yourself, and I will say that Jordan and their team helped on the Dobbs case and the legislation that came through the Mississippi legislature that led to the Dobbs decision. Jordan?
Yes, sir. I'm proud of that association. I do serve as legal counsel in the Center for Public Policy at Alliance Defending Freedom. Thank you for the opportunity to testify regarding this bill. This bill simply applies the clear guidance provided by the United States Supreme Court and the Supreme Court of Mississippi regarding the nature and scope of parental rights, and it applies that to Mississippi's state code. Currently, there are several sections of the code that subvert Mississippi parents' fundamental right to make medical decisions on behalf of their minor children. In the 2023 case Brownlee v. Powell, the Mississippi Supreme Court said it wanted to make clear that parents are the natural guardians of their children, which lead to a presumption that it's in the child's best interest to be in the care of his or her parents. And in the context of medical care, the U.S. Supreme Court has said that most children, even in adolescence, simply are not able to make sound judgments concerning many decisions, including their need for medical care or treatment. Parents can and must make those judgments. And the Fifth Circuit Court of Appeals stated it probably most plainly by saying the state may not interfere with a parent's right to make treatment decisions on behalf of a child. So Senate Bill 2893 accords with these judicial pronouncements of what the Constitution requires. The first job of any government is to protect the fundamental rights of its citizens. And this bill would do that by asserting the fundamental rights of parents and requiring healthcare providers to obtain parental consent before providing healthcare to an unemancipated minor. The bill provides numerous exceptions to the general rule that are grounded in constitutional considerations and real-world experience. The bill doesn't prohibit the provision of emergency medical care or even non-emergency first aid to a child in need. It allows the government to exercise its authority to stop the spread of infectious diseases or look to other responsible parties when a parent's right has been limited by a court. And importantly, it shields providers from any concern about liability when they act in good faith to comply with the law. Parents know and love their children best, and children's health and well-being are best protected when the parents are most involved. This is why courts have consistently held that parents have a fundamental right to direct the upbringing, education, and care, including health care, of their minor children. Absent evidence of abuse or neglect, Parents should be regarded by the state of Mississippi as the ultimate decision makers of what's best for their children. Simply put, no one knows a child's needs better than that child's parents, who have the God-given right and responsibility to make decisions in the child's best interests without undue government interference. This bill would elevate a parent's right to make medical decisions to a top-tier right, ensuring its legal protection. The bill contains important and appropriate provisions that safeguard child welfare and empower government employees to do their jobs within the bounds of the law. It properly balances the rights and responsibilities of parents, children, and the state. And I'd like to close with a final quote from the Supreme Court of Mississippi, which said, while there are very limited and unique situations in which in loco parentis could be used to help rebut the natural parent presumption, the fundamental rights of natural parents remain top tier. Thank you for the chance to testify, and I would welcome any questions you might have.
Thank you, Jordan. At this time, I'm going to open it up to questions from the committee. Senator Boyd?
Mr. Chairman, I have an amendment at the appropriate time.
Okay, we'll get to that at the appropriate time. Any other questions on the bill itself? Okay, I guess this is the time.
In looking at the legislation, there is a clear situation, I think, that the exceptions does not allow for, that we need to allow for. As many of you, I have been on the sideline of many athletic events and recreational sports. And so I believe that in line 64, I would like to add an H. And when medical assistance is rendered by an athletic trainer, nurse, or physician during a school or youth recreation league sporting event. The definitions as they are listed don't really apply to those situations. Most of the time parents are there, but many times they're not. And so it is a little bit more than dressing a wound. Sometimes you're putting a dislocated shoulder back into place. There's many instances on here that it doesn't apply to. The athletic trainers have looked at this. They're very concerned with this, as have many of the physicians and the nurses that take care of our schools and our recreational leagues when they're there. So that's the amendment. I'm happy to answer questions.
Okay. All right. Any questions on the amendment? I think council has that. All right, we're on the amendment. All in favor, say aye. Oh, I'm sorry. Question by Senator McConnell.
I agree with your premise, and I in my neck of the woods, I represent some who have some religious differences of opinion, notably like the Jehovah's Witnesses generally don't want blood products and things of that nature. Are we providing a religious exemption in here for that? Because if we're saying that without parental consent there, all of my powers of attorney for healthcare actually have a provision that's basically what their card says. So I don't want us to overstep that bound in some way.
They are used to operating within those provisions all the time. They take care of children who are of many different religions. These most likely will be associated with a school of somehow, so they'll know how to handle those children. But you haven't allowed for, I don't think, medical assistance when it is needed, with the exceptions that you provided for this to be able to take care of the children.
Provided, however, that the parent's consent is not required when. I think that's my concern, is it kind of oversteps the bounds of what we've got.
Yeah, you're not going to be providing blood transfusions on a soccer field.
Well, yeah, I understand that as well, but I also know that we're attorneys and we don't like slippery slopes, and that's my
I
only.
don't think there's a real slippery slope here when you put it in the practical sense, Senator.
I understand.
Okay, any other questions on the amendment? All right, so if you're in favor of the amendment, say aye.
Aye.
If you're opposed, no. Amendment carries. Thank you very much. All right, any other questions on the bill as amended? All right, no other questions. Do I have a motion, please? Motion is title sufficient, do pass committee substitute. All in favor, say aye. All opposed? Bill carries. All right, two remaining bills that we're going to take up today. And despite Senator Thompson's vociferous questioning of the chairman, we're going to take up Senate Bill 2784, which is his bill. Consumer Protection, Revised Private Cause of Action.
Thank you, Mr. Chairman. Senate Bill 2784 proposes revision to the Mississippi Unfair Trade Practices Act. The Mississippi Unfair Trade Practices Act designates certain specific actions or omissions by individuals in business and provides a claim for its consumer protection, but it's also used by businesses.
Does it include sellers?
It would include sellers and manufacturers as well.
Okay.
So under the current Unfair Trade Practices Act, the individual or business, their only recourse is to go through the Attorney General's office, and the Attorney General's office investigates the claim and then prosecutes the action or not. This would add an option for the individual or business to pursue an Unfair Trade Practices Act claim civilly against that defendant. The purpose is, you know, sometimes you're in situations where maybe there's no contract, maybe there's no warranty. It's not a tort like we think of torts. And so but the Unfair Trade Practices Act and the prohibited acts or practices defined therein do provide a cause of action or fit that fact pattern. And so that would be that's the purpose of the bill, is to provide for that civil cause of action.
Okay, any questions? Anybody want to cross-examine Senator Thompson?
Please.
Apparently not. Do I have a motion? Do I have a motion?
Title sufficient, do pass.
Motion is title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? That carries. Okay, the
Thank you.
last bill for today, I'm going to call up Senate Bill number 2768. This is the judicial redistricting bill. There's no changes from when we passed it in the Senate. We've simply, I'm sorry. Yeah, when we sent it over, and it reflects the conference report that we sent over to the House, which is reflective of what we voted on in the Senate. I will tell you that yesterday, I think it was yesterday, the House advanced the code sections bill on judicial redistricting. Have been since our last meeting, have had conversations. I think those are moving forward. But the bill that's before you is the same thing that we voted on last year and was the conference report that we have. So that's where we are, and I'll be happy to answer any questions on that. If no questions, do I have a motion? Motion is title sufficient, do pass. All in favor, say aye. All opposed? That bill carries. Rise and report. Thank y'all very much. Thank you. I'm gonna run on up to Dudley. I'm gonna do the. I'm not going to Dudley. Well, I was trying to.